Hi friends, in this video we are going to deal with the case summaries of the important Supreme Court judgments pronounced in the year 2022. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button.
So in the important judgment Ram Niwas versus State of Haryana, which was pronounced on 11th of August 2022, the Supreme Court has held that an accused cannot be convicted on the ground of suspension no matter how strong it is. So the facts of the case would be that the accused was accused of murder of the deceased and charges came to be framed for the offences punishable under section 302 and 201 of Indian Penal Code. After trial, the trial court convicted the accused under section 302 of Indian Penal Code. Being aggrieved, the accused preferred an of appeal before the High Court of Punjab and Haryana, and the same came to be dismissed. Hence, the present appeal with the allegation that in the absence of prosecution proving that the dead body was of deceased, the conviction was not sustainable, and the admission of the doctor who conducted post-mortem that the face of the dead body of which he carried the post-mortem was not recognizable were highlighted. The Supreme Court has held that apart from the ocular testimony of prosecution witness number 9, the complainant, who was prosecution witness number 10, the only incriminating circumstances on which the prosecution relies is the recovery of ash and plastic can on the memorandum of the accused under section 27 of Indian Evidence Act. Even according to the complainant and prosecution witness number 10, after they saw the dead body of the deceased in Paral, which is a paddy field, they were not informed anyone in the village. No doubt that how a person responds to a situation is differed from person to person. However, the conduct of the said witnesses in not informing anybody in the village and thereafter going to their village in the morning, returning back in the afternoon and not informing police stations which were in between those two villages cast a serious doubt with regard to the truthfulness of their version. Is further difficult to believe the testimony of these witnesses that in the night the deceased was done to death, set on fire in a paral, which is a paddy field, and they did not come to know about the same till the accused told them about the same next morning. In the evidence of these witnesses, it clearly came out that there were houses surrounding the house of the accused. The prosecution version appears improbable that such an incident took place in an area which is surrounded by houses. The prosecution did also not examine any independent witness residing nearby so as to lend credence to the prosecution's version. The prosecution relies on the extrajudicial confession made by the accused to these witnesses. In the case of S. Arul Raja versus State of Tamil Nadu, which was reported in 2010, 8 SCC 233, it was held that the concept of an extrajudicial confession is primarily a judicial creation and must be used with restraint. Such a confession may be used only in limited circumstances and should also be corroborated by the way of abundant caution. Therefore, it will not be safe to base a conviction solely on the basis of alleged extrajudicial confession made by the appellant to these witnesses. The only other circumstances on which the prosecution relies is the seizure of ash kept in the plastic bag on the memorandum of the accused under section 27 of Indian Evidence Act. Prosecution witness number 11, which is the investigating officer, clearly admitted that the disclosure of statement made by the accused was made in the lockup of the police and is in the heart of the city. He did not call any independent witness as punch or of the said memorandum. As such, the reliance of the said seizure also is of no help to the prosecution's case. Prosecution witness number 5, the doctor admitted that it was difficult to recognize the face of the dead body. From the post-mortem, it is also not established that the death was homicide. The prosecution case rests on the circumstantial evidence. The law with regard to conviction on the basis of circumstances evidence has been crystallized in the judgment of the court in the case of Sharad Bidi Chand Sharda versus State of Maharashtra. It is a very important case and a landmark judgment also. So it was reported in 1984. It was held in this case that the circumstances from which the conclusion of guilt is to be drawn should be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, that they should not be explainable on any other hypothesis except the accused it guilty. The circumstances should be of a conclusive nature and tendency, and they should exclude every possible hypothesis except the one to be proved. And there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. So these 5 golden principles constitute the punch shield of the proof of a case based on circumstantial evidence. Further, the suspicion, however strong it may be, cannot take place of proof beyond reasonable doubt. An accused cannot be convicted on the ground of suspicion, no matter how strong it is. An accused is presumed to be innocent unless proven guilty beyond a reasonable doubt. In the present case, the prosecution has utterly failed to establish the chain of events which can be said to exclusively lead to one and only conclusion, that is the guilt of the accused. So in that view of matter, the judgment and the order of the conviction and sentence of the sessions judge and the judgment and order of the High Court of Punjab in Haryana dismissing the appeal of the accused are quashed and set aside. So the accused is acquitted of all the charges charged with. So that's it for this video. Hope you will find this helpful. If there, just in case if there is any confusion or any questions, you can comment it down in the video.
In the important judgment titled Muni Krishna alias Krishna Extra versus State pronounced on the 30th of September 2022, the Supreme Court has held that videography containing confession made before police is inadmissible as evidence. The facts of the case would be that FIR was registered against accused for the offence punishable under Section 302 of IPC. Police, after its investigation, filed its charge sheet for the offences under Section 302 read with 34 of IPC, against all the accused. After trial, the accused were convicted by the trial court under Section 302 read with Section 34 of IPC. On appeal, the Karnataka High Court upheld the order of conviction and sentence passed by the trial court. Being aggrieved, the present appeal has been filed. The Supreme Court has held that it is a case of circumstantial evidence, and in a case of circumstantial evidence, the entire chain of evidence must be complete, and the conclusions which is arrived after examining the chain of evidence must point towards the culpability of the accused and to no other conclusion. This, however, is clearly missing from the case of the prosecution. The entire case of the prosecution is based on the so-called confessional statements or voluntary statements given by present appellants while they were in police custody. Statement given by an accused to police under Section 161 of CRPC is not admissible as evidence. The so-called evidence discovered under Section 27 of Indian Evidence Act, 1872, that is, the recovery of stolen items and the recovery of the weapon, are also very doubtful. In a case of circumstantial evidence, the court has to scrutinize each and every circumstantial possibility, which is placed before it in the form of an evidence, and the evidence must point towards only one conclusion, which is the guilt of the accused. In the case at hand, the entire case of the prosecution is built upon the confessional or voluntary statements made by the accused before the police, and the recovery of the alleged weapon of murder recovered, at the pointing out of the accused, and the recovery of alleged stolen gold material from a jewelry shop, again, on pointing out of the accused. As per the police, all the accused were arrested from a school building on the 31st of January 2001 and formally arrested on the 1st of February 2001. They confessed to as many as 24 crimes committed by them. Their confessions of how they planned and executed the murders has been captured on a video, which was also exhibited before the court. The court has taken this evidence of voluntary statements made by the accused, and hence admitted it as evidence. This was done both by the Sessions Court as well as the High Court. At this juncture, this court may also add that some of the accused who were before this court were also facing another trial of similar nature, in which they were convicted and sentenced to death. Thereafter, in appeal, their conviction was upheld, but the sentence was converted to life imprisonment by the High Court. They finally came before this court in appeal. The course of investigation and the appreciation of evidence by the trial court and the appellate court had taken a similar course, as they have in the present case. While hearing their criminal appeal numbers 1476 to 1477 of 2018 reported in 2022 SCC Online Supreme Court 765, this court made certain observations, which are equally relevant for the present case as well. This court must add that this court in its order allowed the above appeal, and set aside the order of the Sessions Judge as well as of the High Court, which placed its reliance almost completely on the statement made by the accused, before the police under Section 161 of CRPC. This is exactly what has been done in the present case as well, and consequently, this too must meet the same fate. Indeed, it was also the case of the prosecution that the appellants belong to a gang which commits crime of this nature, and that the modus operandi is by and large the same in all cases. It was alleged that the appellants are involved in as many as 20 to 25 such cases. But what was given before the court was a chart giving description of offences, numbers, and sections under which such offences allegedly committed. No documents in the nature of charge sheet or any other proof was submitted. Therefore, this factor cannot be taken into account. This was also not taken into account by this court in the above order, while allowing the criminal appeal numbers 1476 to 1477 of 2018 as referred above. Ordinarily, this court does not interfere with concurrent findings of facts, as they are in the present case. But, then in the present case, it has become necessary to interfere with the findings for the reasons that, both the High Court as well as the Sessions Court ignored the well-established principles of criminal jurisprudences, and relied upon facts and evidences which are clearly inadmissible. The crime indeed was ghastly, to say the least. Yet, linking the crime to the present appellants is an exercise which was to be undertaken in the court of law under established principles of law. This has not been done. In view of the above, the order of the Sessions Judge and the High Court are hereby set aside. The appellants shall be released from jail, unless they are wanted in some other crime.
So, in the important judgment titled Shahjahan Ismail Muhammad Sheikh vs. State of Maharashtra, which was pronounced on 14 July 2022, the Supreme Court has laid down principles for appreciation of ocular evidence in a criminal case. The facts of the case would be that FIR was registered against the accused for the offence punishable under Section 302 of IPC. In the course of the investigation, the discovery of the weapon of the offence was also drawn under the provisions of Section 27 of Indian Evidence Act 1872. After the trial court accordingly passed the judgment and order of conviction and sentenced the accused to undergo life imprisonment with fine, and in default to suffer further rigorous imprisonment of 1 month. On appeal, the High Court concurred with the findings recorded by the trial court. Being aggrieved, the present appeal has been filed. The Supreme Court has held that the powers of this court under Article 136 of the Constitution are very wide, but in criminal appeals, this court does not interfere with the concurrent findings of fact save in exceptional circumstances. It is open to this court to interfere with the findings of fact recorded by the High Court if the High Court acted perversely or otherwise improperly. It is open to this court to invoke the power under Article 136 only in very exceptional circumstances, as in when a question of law of general public importance arises or a decision shocks the conscience of the court. When the evidence adduced by the prosecution falls short of the test of reliability and acceptability, and as such it is highly unsafe to act upon it. Where the appreciation of evidence and findings is retaliated by any error or of law or of procedure or found contrary to the principles of natural justice, errors of record and misreading of the evidence, or where the conclusions of the High Court are manifestly perversive and unstoppable from the evidence on record. Further, the appreciation of ocular evidence is a hard task. There is no fixed or straitjacket formula for appreciation of the ocular evidence. The judicially evolved principle of appreciation of ocular evidence in a criminal case can be enumerated as the approach must be whether the evidence of the witness read as a whole appears to have a ring of truth. Once that impression is formed, it is necessary for the court to scrutinize the evidence more particularly, keeping in view the deficiencies, drawbacks, and infirmities pointed out in the evidence as a whole, and evaluate them to find out whether it is against the general tenor of the evidence given by the witness, and whether the earlier evaluation of the evidence is shaken as to render it unworthy of belief. If the court before whom the witness gives evidence had the opportunity to form the opinion about the general tenor of the evidence given by the witness, the appellate court, which did not have this benefit, will have to attach due weight to the appreciation of evidence by the trial court, and unless there are reasons weighty, it would not be proper to reject the evidence on the ground of major variations or infirmities in the matter of trivial details. So when the eyewitness is examined at length, it is quite possible for him to make some discrepancies. But court should bear in mind that that is only when discrepancies in the evidence of witness are so incompatible with the credibility of his version that the court is justified in refusing his evidence. Minor discrepancies on trivial matters not touching the core of the case, hyper-technical approach by taking sentences torn out of context here and there from the evidence, attaching importance to some technical error committed by the investigation officer, not going to the root of the matter, should not ordinarily permit rejection of the evidence as a whole. Too serious a view to be adopted on mere variations falling in the narration of an incident, it is unrealistic approach for judicial scrutiny. By and large, a witness cannot be expected to possess a photographic memory and to recall the details of an incident. It is not as if the videotape is replayed on the mental screen. Ordinarily, it so happens that a witness is overtaken by events and the witness could not have anticipated the occurrence, which so often has an element of surprise. The mental faculties, therefore, cannot be expected to be attuned to absorb the details. The power of observation differs from person to person. What one may notice, another person may not notice it. So, an object or the movement might emboss its image on one person's mind, whereas it might go unnoticed on the part of the another. By and large, people accurately recall a conversation and reproduce the very words used by them or heard by them. They can only recall the main purpose of the conversation. It is unrealistic to expect a witness to be a human tape recorder. So in regard to exact time of an incident or the time duration of the occurrence, usually people make their estimates by guessing work on the spur of moment at the time of interrogation. And one cannot expect people to make very precise or reliable estimates in such matters. Again, it depends on the time sense of the individuals, which varies from person to person. So ordinarily, a witness cannot be expected to recall accurately the sequence of events which takes place in rapid succession or in a short time span. So a witness is liable to get confused or mixed up when interrogated later on. So a witness, though wholly truthful, is liable to be overawed by the court atmosphere and the piercing cross-examination by the counsel, and out of nervousness makes up the facts, gets confused regarding the sequence of the events, or fill up details from imagination or spur of the moment. The subconscious mind of the witness sometimes so operates on account of the fear of looking foolish or being disbelieved through the witness is giving a truthful and honest account of the occurrence witnessed by him. A formal statement, though seemingly inconsistent with the evidence, need not necessarily be sufficient to amount to contradiction. Unless the former statement has the potency to discredit the later statement, even if the later statement is at the variance with the former to some extent, it would not be helpful to contradict that witness. Thus, there is nothing palpable or glaring in the evidence of the two eyewitnesses on the basis of which we can take the view that they are not true, reliable eyewitnesses. Few contradictions in the form of omissions here or there is not sufficient to discard the entire evidence of the eyewitnesses. The evidences on record show that except a minor contradiction in the form of an omission, nothing substantial could be elicited from the cross-examination of prosecution witness number 1 so as to render his entire evidence doubtful, and some part of the evidence of the prosecution witness number 8 corroborates the oral testimony of the prosecution witness number 1. The medical evidence on record further corroborates the ocular version of the eyewitness, and the chemical analysis report of the forensic science laboratory indicates that there were stains of human blood on the hammer matching with the blood group of the deceased. Thus, having regard to the aforesaid, both the courts below rightly believe the two eyewitnesses, that is, the prosecution number 1, the prosecution witness number 1 and the prosecution witness number 8 respectively. However, this court noticed a serious infirmity in the reasonings assigned by the trial court as affirmed by the High Court so far as the position of law as regards the discovery of a weapon of offence under section 27 of the Indian Evidence Act is concerned. So if the court overlooks or ignores the same, then probably the trial courts may keep committing the same mistake, and in such circumstances, this court would like to explain the correct position of law and how to appreciate the evidence of discovery in accordance with the provisions of the section 27 of the Act. It is evident that the public prosecutor who conducted the prosecution before the trial court did not take the pains to bring on record the substantive evidence of the aforesaid two witnesses, that is prosecution witness number 4 and prosecution witness number 10 respectively. The fact of the accused having made a statement that he concealed the hammer and he was inclined to show that spot, even though it was recorded in the Panchnama that the accused made such a statement, the public prosecutor does not appear to have realized that there should be a substantive evidence on record in this regard, and that the Panchnama can be used only to corroborate the evidence of the Panch and not as a substantive piece of evidence. It appears that the Panchnamas were shown to the Panch, that is prosecution witness number 4, and he admitted his signatures, and therefore it was exhibited in number 22 and 23 respectively. The examination in chief of prosecution witness number 4 does not show that he read over the Panchnama before it was exhibited. This court time and again impressed upon the necessity of reading over the Panchnama, which can be used as a piece of corroborative evidence. In spite of this, it is regrettable that the trial judge did not take the pains to see that the Panchnama was read over to the Panch before it was exhibited. It is therefore necessary that the care is taken by the public prosecutor who conducts the trial that such a procedure is followed while examining the Panch at the trial. It is also necessary that the trial judge also sees that the Panchnama is read over to the Panch and therefore the Panchnama is exhibited after the following procedure is as indicated. One of another serious infirmity which surfaced is as regards the authorship of concealment by the person who is said to have discovered the weapon. Mere discovery cannot be interpreted as sufficient to enter authorship of concealment by the person who discovered the weapon. He could have derived knowledge of the existence of that weapon at the place through some other source also. He might have even seen somebody concealing the weapon, and therefore it cannot be presumed or interfered that because a person discovered a weapon, he was the person who concealed it. Least it can be presumed that he used it. Therefore, even if discovery by the appellant is accepted, what emerges from the substantive evidence as regards the discovery of weapon is that the appellant disclosed that he would show the weapon used in the commission of offence. Thus, in the absence of exact words attributed to an accused person, a statement made by him being deposed by the investigating officer in his evidence, and also without proving the contents of the Panchnamas. The trial court was not justified in placing reliance upon the circumstances of discovery of weapon. Even while discarding the evidence in the form of discovery Panchnama, the conduct of the appellant would be relevant under section 8 of the Act. The evidence of discovery would be admissible as conduct under section 8 of the Act, quite apart from the admissibility of the disclosure statement under section 27. Although the conduct of an accused may be a relevant fact under section 8 of the Act, yet the same by itself cannot be a ground to convict him or hold him guilty, and that too for a serious offence like murder. Like any other piece of evidence, the conduct of the accused is also one of the circumstances which the court may take into consideration along with the other evidences on record, which might be direct or which might be indirect. What this court is trying to convey is that the conduct of the accused alone, though may be relevant under Section 8 of the Act, cannot form the basis of conviction. In the ultimate analysis, this court has reached to the conclusion that there is no merit in the present appeal. So, in the important judgment titled Mrs. Akela Lalitha versus Shri Konda Hanumantha Rao and others, which was pronounced on 28th of July 2022, the Supreme Court has held that a mother who remarries after the death of the biological father can decide the surname of the child and include it in her new family. The facts of the case would be that the dispute between the mother who remarried another man after death of first husband and the parents, if the deceased biological father of the child, was about the surname that should be given to the child. The respondents, grandparents of the child, filed the petition under Section 10 of the Guardian and Wards Act 1890 for appointing them as guardians of Master ALR Achinta, son of the applicant. The trial court dismissed the petition filed by the respondents, holding that it would not be appropriate to separate the child from the love and affection of his mother. However, granted visitation rights to the respondents. So, on appeal, the High Court directed that whatever the records permit, the name of the natural father shall be shown, and if it is otherwise impermissible, the name of Ravi Narasimha Sharma shall be mentioned as stepfather amidst other discussions. Being agreed, the present appeals have been filed. The issues posed for consideration are: number one, whether the mother, who is the only natural or legal guardian of the child after death of the biological father, can decide the surname of the child. Can she give him the surname of her second husband, who she remarries after the death of her first husband? And can she give the child for adoption to her husband? And number two was whether the High Court has the power to direct the appellant to change the surname of the child, especially when such relief was never sought by the respondents in their petition before the trial court. The Honorable Supreme Court has held that after the demise of a first husband being the only natural guardian of the child, this court fails to see how the mother can be lawfully restrained from including the child in her new family and deciding the surname of the child. A surname refers to the name of the person shares with the members of the family of that person, distinguished from the person given name or the names of family name. Surname is not only indicative of lineage and should not be understood just in context of the history, culture and lineage, but more importantly, the role it plays is with regard to the social reality along with the sense of being for children in their particular environment. So, the direction of the High Court to include the name of the appellant's husband as a stepfather in document is almost cruel and mindless of how it would impact the mental health and self-esteem of the child. This court therefore sees nothing unusual in appellant mother upon remarriage having given the child the surname of her husband or even given the child in adoption to her husband. While an adoption deed is not necessary to effect adoption and the same can be done even through established customs, in the present case the appellant submits that during the pendency of the present petition, the husband of the appellant, that is the stepfather of the child, adopted the child by way of registered adoption deed. Now Section 12 of the Hindu Adoptions and Maintenance Act 1956 provides that an adoption child can be deemed to be the child of his or her adoptive father or mother for all purposes with effect from the date of the adoption, and from such date all the ties of the child and the family of his or her birth shall be deemed to be severed and replaced by those created by the adoption of the adopted family. While the main object of adoption in the past has been to secure the performance of one's funeral rites and to preserve the continuance of one's lineage, in recent times the modern adoption theory aims to restore family life to a child deprived of his or her biological family. Therefore, the first issue is settled in favor of the appellant. While this court is not apathetic to the predicament of the respondent grandparents, it is a fact that absolutely no relief was ever sought by them for the change in surname of the child to that of the first husband. So it is settled law that relief not found on pleadings should not be granted. If a court considers or grants a relief for which no prayer or pleading was made, depriving the respondent of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice. In the present case, while directing for change of surname of the child, the High Court traversed beyond pleadings, and such directions are liable to be set aside on the grounds the mother, being the only natural guardian of the child, has the right to decide the surname of the child. She also has the right to give the child in adoption. The court may have the power to intervene, but only when a prayer specific to that effect is made, and such prayer must be centered on the premise that the child's interest is the primary consideration and it outweighs all the other considerations. Thus, the directions of the High Court, so far as the surname of the child is concerned, are set aside.
Hi friends, in this video we are going to deal with the important judgment titled as Muni Devi alias Nadi Devi dead through legal representatives and others versus Rajendra alias Lalu Lal dead through legal representatives and others, pronounced on 18th May 2022. The facts of the case would be that the original plaintiff filed the suit for possession of the suit property along with the mesne profits against the original defendant and against the other defendants who were the tenants in the suit property. Pending suit, original plaintiff and original defendant number 1 expired. Thereafter, the suit was prosecuted by their legal representatives. The suit was decreed by the trial court, against which the first appeal was preferred by the legal representatives of the defendant number 1. Pending the appeal, daughter of the original plaintiff also expired, and her legal representatives were substituted in her place. The said first appeal having been allowed by the High Court, the present appeal has been filed by the heirs and legal representatives of the daughter of the original plaintiff, with allegation that the High Court committed an error in holding that a limited right in the suit property was created in favor of defendant number 1, and that she had a right of maintenance even under the old Sastric law, which fructified into a full right under section 14(1) of the Hindu Succession Act 1956, whereas the respondents argued that the exclusive possession of a widow of Hindu undivided family property itself would create a presumption that such property was earmarked for realization of her pre-existing right of maintenance, more particularly when the surviving co-partner did not earmark any alternative property for recognizing her pre-existing right of maintenance. The issue raised for consideration is whether defendant number 1, the predecessor of the present respondents, became an absolute owner on coming into force the Act of 1956. The Supreme Court has held that Section 14(1) reads that in order to become a full owner and not a limited owner of a property by virtue of Section 14(1), a female Hindu before or after the commencement of Act 1956 must be in possession of the property, and it must have been acquired by her by inheritance or devise or at a partition or in lieu of maintenance or arrears of maintenance or by gift from any person, whether a relative or not, before, at or after her marriage, or by her own skill or exhaustion, or by purchase or by prescription, or in any other manner whatsoever, or any such property must have been held by her as Sridhana immediately before the commencement of the Act. In the instant case, this court is concerned with the claim of defendant number 1 of having become the full owner in respect of the suit property on the ground that she was in settled legal possession of the suit property before and after the commencement of the Act, in lieu of her pre-existing right of maintenance, and such limited ownership right had fructified into full ownership by virtue of Section 14(1). Referring to the judgments in V. Tulasamma and others versus Sesha Reddy dead, reported in 1977, 3 SSC 99, and Raghubar Singh and others versus Gulab Singh and others, reported in 1998, 6 SSC 314, it has been held that there remains no shadow of doubt that a Hindu woman's right to maintenance was not and is not an empty formality or an illusory claim being considered as a matter of grace and generosity. It is a tangible right against the property which flows from the spiritual relationship between the husband and the wife. The said right was recognized and enjoined by pure Sastric Hindu law, which existed even before the passing of 1937 or the 1946 Acts. Those acts merely gave statutory backing, recognizing the position as was existing under the Sastric Hindu law, where a Hindu widow is in possession of the property of her husband or of the husband's Hindu undivided family. She has a right to be maintained out of the said property. She is entitled to retain the possession of that property in lieu of her right to maintenance. Section 14.1 and the explanation thereto envisages liberal construction in favor of the females with the object of advancing and promoting the socio-economic ends sought to be achieved by the said legislation. As explained in V. Tulasamma case, the words possessed by used in section 14.1 are of the widest possible amplitude and include the state of owning a property even though the Hindu woman is not in actual or physical possession of the same. Of course, it is equally well settled that the possession of the widow must be under some vestige of a claim, right or title, because the section does not contemplate the possession of any rank trespasser without any right or title. Facts on record would show that different number 1 had long settled possession of the suit property which she acquired in lieu of her pre-existing right to maintenance prior to the commencement of Act 1956, which entitled her to become a full owner of the suit property by virtue of section 14.1. Her exclusive possession of suit property after the death of father-in-law's brother in 1953, that is, prior to coming into force of said act in 1956, was not only not disputed but was admitted by the plaintiff in the plaint itself. Her pre-existing right to maintenance from the estate of the Hindu undivided family of her husband was also well established. The submission of the appellants that mere right to maintenance would not ipso facto create any charge on the property, and that for creating legal charge, recognizing right of Hindu women to maintenance required execution of a document, device or agreement cannot be countenanced. Her pre-existing right to maintenance coupled with her settled legal possession of the property would be sufficient to create a presumption that she had a vestige of right or claim in the property, though no document was executed or specific charge was created in her favor recognizing her right to maintenance in the property. Therefore, the High Court rightly held that different number 1 had pre-existing right to maintenance in the suit property that ripened into full ownership by virtue of section 14.1. Hi friends, in this video we are going to deal with the important judgment titled Consolidated Construction Consortium Limited versus Hydro Energy Solutions Private Limited, pronounced on 4th February 2022. The facts of the case would be that a project was executed by appellant with Chennai Metro, in the course of which the Chennai Metro placed an order for supply of light fittings. In turn, the appellant placed orders with the proprietary concern, the supplier of Thorn Lighting India Private Limited. The proprietary concern requested the appellant for an advance payment which was paid by Chennai Metro. After some time, the project stood terminated and Chennai Metro informed the appellant that the amount would be deducted from the dues payable to it unless the amount was written. The appellant paid the amount and intimated the same to the proprietaries concerned and requested them for refund. It noted that once the amount was released by the proprietary concern, it would indemnify them against any future claim from the Chennai Metro. In its reply, the proprietary concern stated that it would return the amount directly to Chennai Metro. Meeting was held with regard to the same. Finally, the proprietary concern noted that the appellant should obtain a letter from Chennai Metro. Thereafter, the appellant obtained a letter which was sent to the proprietary concern, but no payment was made. The appellant sent a Form 3 demand notice under Section 8 of the IBC to the respondent, which denied that any debt was owed by them to the appellant. Thereafter, the appellant filed its application under Section 9 of the IBC, read with Rule 6 of the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. By its judgment, the NCLT admitted the application under Section 9 of the IBC, declared a moratorium under Section 14 of the IBC, and appointed an interim resolution professional. The order of the NCLT was set aside by the NCLAT. Thus, the present appeal has been filed before the Supreme Court. The issues posed for consideration are whether the appellant is an operational creditor under the IBC even though it was a purchaser, whether the respondent took over the debt from the proprietary concern, and whether the application under Section 9 of the IBC is barred by limitation. The Supreme Court has held that Section 521 defines operational debt as a claim in respect of the provision of goods and services. The operative requirement is that the claim must bear some nexus with the provision of goods or services without specifying who is to be the supplier or receiver. Such an interpretation is also supported by the observations in the Bankruptcy Law Reforms Committee report, which specifies that operational debt is in relation to operational requirements of an entity. Section 8.1 of the IBC, read with Rule 5.1 and Form 3 of the 2016 application rules, make it clear that an operational creditor can issue a notice in relation to an operational debt either through a demand notice or an invoice. As such, the presence of an invoice is not a sine qua non, since a demand notice can also be issued on the basis of other documents which prove the existence of the debt. This is made even more clear by Regulation 72B1 and 2 of the Corporate Insolvency Resolution Process Regulations 2016. Hence, this leaves no doubt that a debt which arises out of an advance payment made to a corporate debtor for supply of goods or services would be considered as an operational debt. Similarly, in the present case, the phrase "in respect of" in Section 521 has to be interpreted in a broad and purposive manner in order to include all those who provide or receive operational services from the corporate debtor, which ultimately lead to an operational debt. The appellant clearly sought an operational service from the proprietary concern when it contracted with them for the supply of light fittings. Further, when the contract was terminated, but the proprietary concern nonetheless encashed the check for advance payment, it gave rise to an operational debt in favor of the appellant, which now remains unpaid. Hence, the appellant is an operational creditor under Section 520 of the IBC. Further, the Memorandum of Association of the respondent states that one of its main objects is to take over the proprietary concern. However, the respondent has produced a resolution passed by its board of directors purportedly resolving to not take over the proprietary concern. But there was no reference to the resolution in the counter statement and additional counter statement filed before the NCLT. The conduct of the respondent in bringing up this resolution for the first time before the NCLAT would lead to an adverse inference against them for having suppressed this document earlier, if at all it was in existence. In any case, Section 13 of the Company Act 2013 provides for the procedure which has to be followed when the MOA is to be amended. In cases where the object class is amended, it requires the registrar to register the special resolution filed by the company. However, the respondent has provided no proof. Thus, in terms of Section 1310 of the Company Act 2013, the purported amendment to the MOA would not have any legal effect. Consequently, the MOA of the respondent still stands and the presumption will continue to be in favor of the appellant. Thus, it can be concluded that the respondent took over the property concern and was liable to repay the debt to the appellant. Hence, the application under Section 9 of the IBC was maintainable. Further, the facts on the record would show that the application under Section 9 of the IBC will not be barred by limitation. In the crucial judgment titled The Employees Provident Fund Organization and Another, etc., versus Sunil Kumar and others, etc., pronounced on 4th November 2022, the legality of certain amendments and modifications made by the central government to Employees Pension Scheme 1995 was being dealt, and for which the High Courts of Kerala, Rajasthan and Delhi gave their verdicts in favor of employees, and they are under challenge in appeals before this court. Further, 54 writ petitions were also filed by the employees themselves or on their behalf under Article 32 of the Constitution, seeking invalidation of the notification dated 22nd August 2014, that is the Employees Pension Amendment Scheme 2014. Along with those appeals, these writ petitions were also addressed. The Supreme Court has held that classification of the employees made by the authorities on the basis of the salary drawn in the 2014 amendment meets the test of reasonable classification contemplated in Article 14 of the Constitution. The requirement in the scheme for employees' contribution to the extent of 1.16% for option members is illegal. There is nothing in the Employees Provident Funds and Miscellaneous Provisions Act 1952 which requires payment to the pension fund by an employee. Section 6A of the 1952 Act also does not have any such stipulation. Since the 1952 Act does not contemplate any contribution to be made by an employee to remain in the scheme, the central government under the scheme itself cannot mandate such a stipulation. What is to be considered here is that for the mandatory members, the central government continues to contribute the requisite 1.16% of their salary. For option members, additional contribution by them is contemplated in order to remain in the scheme. In such a situation, a legislative amendment of the 1952 Act would have been necessary, providing for contribution to be made by an employee. To that extent, the provision of the scheme requiring contribution by an individual employee is ultra vires the Parent Act. At the same time, the pension amount to be paid is calculated on projections that the corpus would include the option employee's additional contribution of 1.16%. This court also cannot mandate the central government to contribute to a pension scheme in absence of a legislative provision to that effect. It would be for the administrators to readjust the contribution pattern within the scope of the statute, and one possible solution could be to raise the level of the employee's contribution in the scheme. This court shall, however, suspend the operation of this part of judgment of this court for a period of 6 months so that the legislature may consider the necessity of bringing appropriate legislative amendment on this count. For the aforesaid period, the scheme as it stands shall continue. Till such time, if no such legislative exercise is undertaken, the duty to contribute 1.16% of the salary shall apply on option members as well. This contribution shall be adjusted depending on any amendment that may be brought. For the period of 6 months, however, the opting employees shall make payment of 1.16% contribution as stop-gap measure. In the event no amendment to the statute or the scheme is made within such extended time, then the administrators of the fund will have to operate the pension fund for the option members from out of the existing corpus. The other aspect of the controversy involves changing the method of computation of the pensionable salary. This change of methodology comes within the power of the central government to modify a scheme under Section 7 of the 1952 Act, read with Item 10 of the Schedule 3 to the Act, as also paragraph 32 of the scheme. This alteration of the computation is ancillary to determination of scale of pension along with pensionary benefits, and para 32 of the pension scheme specifically authorizes the central government to alter the rate of contribution payable under the scheme or the scale of any benefit admissible under the scheme. There is a reasonable basis for effecting change in the computation methodology for determining pensionable salary, and this court does not find any illegality or unconstitutionality in effecting this amendment. This court finds from Section 17A of the 1952 Act that the investment of the Provident Fund for the Trust Fund are also to be as per the directions of the central government. In quashing the circular dated 31st May 2017, the Delhi High Court held that the employees of unexempted establishments and exempted establishment form a homogeneous group. Section 6A of the Act also envisages coverage of employees of exempted establishments under Section 17(6) of the 1952 Act within the pension scheme. Further, Class 1(3) of the pension scheme contemplates keeping within its fold the establishments to which the 1952 Act applies. These establishments would include exempted establishments as well. The employees of exempted establishments are integrated into the pension scheme, and the employees of an exempted establishment should not be deprived of the benefit of getting option to remain in the pension scheme while drawing salary beyond the ceiling limit in situations where similarly situated employees of unexempted establishments can exercise such option. In the event the scheme is construed in a way which would exclude them, that would lead to artificial classification of otherwise same categories of employees. Thus, the pension scheme ought to apply to the employees of the exempted establishments in the same manner as this scheme applies to the employees of unexempted or regular establishments. In order to be entitled to the benefits of the pension fund, the employer and the employee simultaneously with exercising option in the terms of the order of this court shall also have to give an undertaking of transferring the employer's contribution at the stipulated rate maintained by the trust, which shall be equivalent to and not lower than the sum which would have been transferable had such fund been maintained by the Provident Fund authorities. Such transfer shall take place immediately after exercise of such option within such period as may be directed by the administrators of the pension fund. Further, the dual option as is contemplated in paragraph 11(4) of the pension scheme post 2014 amendment has to be merged into one. In the event the employer and employee jointly opt for coverage beyond the salary limit of rupees 15,000 without giving an earlier option under the unamended class 11(3) of the pension scheme, they would not be automatically excluded from their right to exercise option under para 11(4) of the scheme post amendment. The other condition for enhanced coverage relates to the date within which such fresh option is to be exercised by a member, which is stipulated to be within a period of 6 months from 1st September 2014. It would be legitimate to proceed on the basis that several members did not exercise such option earlier because of the stand taken by the Provident Fund authorities that option under proviso to para 11(3) of the scheme prior to 2014 amendment has to be exercised within a specified date, which stand was negated in the decision of R.C. Gupta and others versus Regional Provident Fund Commissioner, Employees Provident Fund Organization and others, reported in 2018-14 ACC 809. The time limit for coverage beyond the ceiling amount should be extended by a further period of 4 months from today to enable all the members of the pension fund drawing more than rupees 6,500 to exercise the joint option as contemplated in para 11.4 of the pension scheme post 2014 amendment. One such joint option exercise, the transfer of fund from the Provident Fund corpus to the pension fund, shall be effected in the terms of the scheme. Thus, the provisions contained in the notification dated 22nd August 2014 are legal and valid. Amendment to the pension scheme brought about by the notification dated 22nd August 2014 shall apply to the employees of the exempted establishments in the same manner as the employees of the regular establishments. A transfer of funds from the exempted establishments shall be in the manner as directed. The employees who exercised option under the proviso to para 11.3 of the 1995 scheme and continue to be in service as on 1st September 2014 will be guided by the amended provisions of para 11.4 of the pension scheme. The members of scheme who did not exercise option as contemplated in the proviso to para 11.3 of the pension scheme as it was before 2014 amendment would be entitled to exercise option under para 11.4 of the post amendment scheme. Their right to exercise option before 1st September 2014 stands crystallized in the judgment of this court in the case of R.C. Gupta. The scheme as it stood before 1st September 2014 did not provide for any cutoff date, and thus those members shall be entitled to exercise option in terms of para 11.4 of the scheme as it stands at present. The exercise of option shall be in the nature of joint options covering pre-amended para 11.3 as also the amended para 11.4 of pension scheme. All the employees who did not exercise option but were entitled to do so but could not due to the interpretation on cutoff date by authorities ought to be given a further chance to exercise their option. Time to exercise option under para 11.4 of the scheme under these circumstances shall stand extended by a further period of 4 months. The employees who retired prior to 1st September 2014 without exercising any option under para 11.3 of the pre-amended scheme have already exited from the membership thereof. They would not be entitled to benefit of this judgment. The employees who retired before 1st September 2014 upon exercising option under para 11.3 of the 1995 scheme shall be covered by the provisions of the para 11.3 of the pension scheme as it stood prior to the amendment of 2014. The requirement of the members to contribute at the rate of 1.16% of their salary to the extent such salary exceeds rupees 15,000 per month as an additional contribution under the amended scheme is held to be ultra vires the provisions of the 1952 Act. This court suspends operation of this part of this court's order for a period of 6 months. This court does so to enable the authorities to make adjustments in the scheme so that the additional contribution can be generated from some other legitimate source within the scope of the Act, which could include enhancing the rate of contribution of the employers. This court is not speculating on what steps the authorities will take, as it would be for the legislature or the framers of the scheme to make necessary amendment. For the aforesaid period of 6 months or till such time any amendment is made, whichever is earlier, the employee's contribution shall be a stopgap measure. The said amount or said sum shall be adjustable on the basis of alteration to the scheme that may be made. This court agrees with the view taken by the division bench in the case of R.C. Gupta so far as interpretation of the proviso to para 11.3 pre-amended pension scheme is concerned. The fund authorities shall implement the directives contained in the said judgment within a period of 8 weeks, subject to this court's directions contained earlier in this para. In the important judgment titled The Regional Director or Recovery Officer and Another versus Nitinbhai Vallabhai Panchasara pronounced on 17th November 2022, the authorities sent demand notice to the respondent organization demanding money for specific period. Being dissatisfied, the respondent filed ESI application and it was rejected by the ESI court. Thereafter, the authority passed an order covering the respondent under the provisions of the ESI Act and the same was challenged. Thereafter, the respondent started paying ESI contribution. However, as there was a delay in making the payment, the authority issued demand notices with interest. The demand of interest leviable under Section 39(5)(a) of the ESI Act was again challenged. ESI court restricted the amount of interest to 2 years only. The order passed by the ESI court was the subject matter before the Gujarat High Court, which in turn dismissed the appeal. Being aggrieved, the present appeal has been filed with an issue posed for consideration, and it is whether the ESI court was justified in restricting the levy of interest under Section 39(5)(a) for a period of 2 years only. The Supreme Court has held that Section 39(5)(a) provides that if any contribution payable under this Act is not paid by the principal employer on the date on which such contribution has become due, he shall be liable to pay simple interest at the rate of 12% per annum or at such higher rate as may be specified in the regulations till the date of its actual payment. The word used in Section 39(5)(a) is shall. Therefore, the interest leviable is a statutory liability to pay the interest. Neither the authority nor the court have any authority to either waive the interest and or reduce the interest and or the period during which the interest is payable. The order passed by the ESI court shows that the ESI court reduced the period of interest to 2 years only. The same is not supported by any statutory provision. Section 39(5)(a) provides that the liability to pay the interest is from the date on which such contribution has become due until the date of its actual payment. Therefore, the ESI court was not justified at all in reducing the period of interest to 2 years only. The respondent was liable to pay the interest under Section 39(5)(a) from the date on which the contribution became due and payable until the date of actual payment. Further, the ESI court erred in relying upon the case of Employees State Insurance Corporation versus HMT Limited and another, reported in 2008 3 SSC 35, while considering the levy of interest under Section 39(5)(a). Therefore, the impugned judgment and order passed by the High Court and that of the ESI court are hereby quashed and set aside. The respondent is liable to pay the interest under Section 39(5)(a) from the date of contribution due and payable till the actual payment. In the important judgment titled Revenue Divisional Officer and Another versus Ismail Bai and others, pronounced on 22nd November 2022, the disputed land was acquired for extension of Nehru Zoological Park in 1981. Despite taking possession, award was not passed and no amount of compensation was paid. The landowners filed a writ petition before the Andhra Pradesh High Court, which was disposed directing the Revenue Department to pass an award within a period of 3 months. Only thereafter, award was passed and a meager compensation at the rate of ₹6 per square yard was awarded to the landowners. Later, the reference court enhanced the compensation to ₹250 per square yard with solatium and interest. The enhancement was questioned by the Revenue Department by filing appeals before the High Court. The landowners also filed an appeal questioning the adequacy of compensation. Thereafter, in the year 2017, appeal filed by the Revenue Department was allowed by High Court, reducing the compensation to ₹100 per square yard. Being aggrieved, the present appeals have been filed. The Supreme Court has held that the facts on record show that the acquisition of land was made in the year 1981. The land acquired is situated in a highly developed area of the Twin Cities, having amenities of water, electricity, drainage, telephone, transport, etc. Exhibits A2 and A3 are the decrees passed in two similar cases in which the compensation was fixed at the rate of Rs 250 per square yard of the land acquired at the same time. The said documents find support from the testimony of PW1 and PW2. The evidence as produced by the landowners was not rebutted. On the contrary, the departmental witness admitted before the reference court that the acquired land of the village is a prominent area within the vicinity of the city of Hyderabad. In the absence of having any material on record, the reference court rightly relied on Exhibit A1, the sale deed of adjacent village Bahadurpur. Also, the letter of Revenue Department officer acknowledges minimum value at the rate of Rs 200 per square yard on the date of acquisition. Therefore, the High Court erred in computing the compensation at the rate of Rs 100 per square yard, ignoring the unrebuted documents produced by the landowners and without any cogent material on record by applying reverse calculation. As per the testimony of the departmental witness, the RW2, it is clear that the land acquired is near to the Agricultural University, National Police Academy and High Court of Andhra Pradesh. Considering the aforesaid and taking note of the date of acquisition, that is 1981, which is about 40 years ago, the value of the said land cannot be computed at the rate less than Rs 250 per square yard, which is supported by the evidence brought on record by the landowners. Recently, in the case of Reddy Veeranna versus State of Uttar Pradesh and others, reported in 2022 SEC Online 562, the deduction of the development charge was denied. The facts of the present case are not uncommon to the said case. Further, it is apparent that the land in the present case was acquired 40 years back in the year 1981 and the compensation was decided by the land acquisition officer after litigating in courts only at the rate of Rs 6 per square yard. The land acquired is now in the heart of the city of Hyderabad, where the cost of the land has been increased more than 100 times. The development of the city has already taken place. The landowners whose land has been utilized 40 years back now cannot be compelled to pay the development charge for the development which has already taken place only for a parcel of land to which they have not given compensation up to decades. Therefore, the plea taken by the Revenue Department stands merit. Thus, the impugned judgment passed by the High Court stands set aside, restoring the order of the reference court. The amount of compensation as determined by the reference court be calculated and be paid now within 2 months.
Important judgment titled Qazi Moinuddin Qazi Bashiruddin and others versus the Maharashtra Tourism Development Corporation through its senior regional manager, regional office, MTDC, Aurangabad, Maharashtra and another pronounced on 30th September 2022. The Supreme Court has held that when two views are possible, the view that advances the cause of justice is always to be preferred, rather than the technical view, while dealing with payment of compensation to land losers. The facts of the case would be that the case of the respondents before the High Court was that 50% of the amount of compensation awarded by the reference court was already deposited, in terms of the order passed by the High Court, and the said order having not been altered by any court, they mistakenly deposited further an amount of 1,37,50,547 rupees and were entitled to withdraw the same. However, the present appellants asserted before the High Court that, in terms of the order passed by this court in Civil Appeal number 1348 of 2018, the said order stood modified because this court directed release of 50% of the amount of compensation with security and remaining 50% without security. In the impugned order, the High Court accepted the submissions made on behalf of the respondents and allowed them to withdraw the aforesaid amount. Being aggrieved, the present appeal has been filed. The Supreme Court has held that when only the disbursal order was in challenge before this court, and the principal order, that is stay order requiring only 50% deposit was not in question, the order passed by this court correlates only with the disbursal order, and thereby, the appellants would be entitled to withdraw 50% of the deposited amount without security, and balance 50% on furnishing security. However, a close look at the order dated 29 January 2018, and the relied upon order therein bring to fore a situation entirely different, and it is difficult to accept the submissions of the respondents, as also the observations of the High Court that this court's order related only to the deposited amount of compensation, and not to the entire enhanced amount of compensation. Also, the common thread running through all the orders passed by this court in earlier cases is that this court issued similar directions of allowing 50% of enhanced amount of compensation to be released without security, and balance 50% to be released on furnishing security. So far as the decision of this court in Civil Appeal number 4102 to 4103 of 2020 is concerned, therein the High Court stayed the execution of award passed by the reference court, on the condition of the acquiring agency depositing 80% of the awarded amount, along with proportionate cost and interest, and thereafter, the High Court directed that 50% of the deposited amount be placed in a cumulative fixed deposit for a period of 5 years, and the balance was allowed to be withdrawn by the claimants. The High Court also allowed the claimants to withdraw 50% of the accrued interest on fixed deposit. Taking note of the given fact situation, and the fact that the claimants were not in a position to furnish any security, this court issued directions for depositing entire awarded amount before the High Court, and then allowed 25% of the deposited amount to be withdrawn by the claimants without security, and the remaining 75% was ordered to be placed in a cumulative fixed deposit for a period of 5 years. The said case essentially proceeded on its own facts, and it cannot be held that this court laid down any inflexible rule that, in every such case, the claimants would be entitled to withdraw only 25% of the awarded amount of compensation. Further, fact of the matter remains that, in the present case, specific order was passed by this court, in terms of the order passed in the case of Wajid Mia Abdul Rahman Shak and others versus Maharashtra in Dev. Kaur and others, Civil Appeal number 8056 of 2013. The order passed by this court was explicit that the order of the High Court staying the payment of enhanced compensation stood modified to the effect that 50% of the enhanced amount of compensation was to be released without security, and the balance 50% on furnishing security. Even if the initial stay order dated 14 December 2016 was not, as such, challenged before this court, the disbursal order was essentially in continuity thereof, and while considering challenge to the disbursal order, nothing prevented this court from modifying the principal stay order itself. The order dated 29 January 2018 passed by this court in Civil Appeal number 1348 of 2018 is required to be interpreted and applied on its substance rather than technicalities. The intent of this court in Wajid Mia Abdul Rahman Shak case was clear that the entire amount of enhanced compensation should reach the claimants, while they would be obliged to furnish security to the extent of 50%. When the same terms were applied to the present case, the attempt on the part of the respondents to fall back again and again on the order dated 14 December 2016 could not have been countenanced. The High Court fell in such an error by accepting the hyper-technical submissions on behalf of the respondents. In fact, the respondents correctly understood the meaning, purport, and effect of the order dated 29 January 2018 in the first instance, when the remaining 50% of the amount of compensation was deposited on 20 March 2018. Their second thought, and late attempt to withdraw the said amount was required to be rejected. Thus, the orders passed by the courts, and particularly by this court, are required to be understood on their pith and substance, while avoiding an approach of technicalities. Moreover, when the matter relates to the payment of amount of compensation to the land losers, if at all two views are possible, the view that advances the cause of justice is always to be preferred, rather than the other view, which may draw its strength only from technicalities.
Now we are going to deal with the important judgment titled Tedi Singh versus Narayan Das Mahant, pronounced on 7th March 2022. In this judgment, the Supreme Court has held that it cannot be expected of a complainant to initially lead evidence to show that he had financial capacity unless such a case was set up in the reply notice by the accused. The facts of the case would be that the appellant was in urgent need of money, and out of friendship the respondent gave a sum of rupees 7 lakhs, and the check given by the appellant was dishonored. The Chief Judicial Magistrate found the appellant guilty of having committed the offence under Section 138 of the Negotiable Instruments Act 1881, and the same was affirmed by the Sessions Judge. The revision filed by the appellant was also dismissed by the Himachal Pradesh High Court. Being aggrieved, the present appeal has been filed with allegation that this is a case where the High Court as also the two lower courts have not appreciated the law which is laid down in regard to the effect of a probable defence. The counsel for the appellant also pointed out that this is a case where, contrary to the finding of the trial court, a reply notice was in fact given by the appellant as admitted by the complainant. The Supreme Court has held that Section 139 provides that court shall presume the holder of the check received the check of the nature referred to in Section 138 for the discharge in whole or in part of any debt or other liability. This presumption, however, is expressly made subject to the position being proved to the contrary. In other words, it is open to the accused to establish that there is no consideration received. It is in the context of this provision that the theory of probable defense has grown. The principle has developed that all which the accused needs to establish is a probable defense. As to whether a probable defense has been established is a matter to be decided on the facts of each case, on the conspectus of evidence and circumstances that exist. There is some merit in the complaint of counsel for the appellant that the High Court has not appreciated the real purpose of examining DW1 to DW4. She is also correct when she drew the attention to the accounts of the Grameen Bank to show that before 5th of August 2011, the appellant stopped operating the account in the said bank, and a very small and ignorable amount alone was available in the said account. The trial court and the first appellate court noted that in the case under Section 138, the complainant need not show in the first instance that he had the capacity. The proceedings under Section 138 is not a civil suit. At the time when the complainant gives his evidence, unless a case is set up in the reply notice to a statutory notice sent that the complainant did not have the wherewithal, it cannot be expected of the complainant to initially lead evidence to show that he had the financial capacity. To that extent, the courts were right. However, the accused has the right to demonstrate that the complainant did not have the capacity, and therefore the case of the accused is acceptable, which he can do by producing independent materials. It is also open to him to establish the very same aspect by pointing to the materials produced by the complainant himself. He can further achieve this result through the cross-examination of the witnesses of the complainant. Ultimately, it becomes the duty of the courts to appreciate the totality of the evidence and then conclude whether the accused has shown that the case of the complainant is in peril for the reason that the accused established a probable defense. But in the reply notice, the appellant has not set up any case that the respondent did not have the financial capacity to advance the loan. Also, at the time when the reply notice was sent, the case is not set up against the loss of checkbook and about the check relied upon by the respondent being one which is brought into existence using the loss signed check leaf. Further, there is no evidence to establish that the appellant informed the bank about the loss of the checkbook containing blank check, and the signature of the check was not put by him. Therefore, in the totality of the present case, the appellant has not established a case for interference with the finding of the courts below. The amount of compensation in question has been deposited already in the trial court. However, the appellant should be granted relief in the form of substitution of the sentence of imprisonment of 1 year with a fine. An amount of rupees 5,000 should suffice as substitution for the imprisonment. Apart from that, this court would also direct that a further amount of rupees 15,000 shall be paid as compensation to the respondent.
The important judgment titled Dashrathbhai Trikambhai Patel vs Hitesh Mahendrabhai Patel and another, pronounced on 11th October 2022, the Supreme Court has held that no offence for dishonor of cheque under Section 138 of the Negotiable Instruments Act is made out if the cheque is presented for the full amount without endorsing the part payment made by the borrower after the issuance of the cheque. The facts of the case would be that the cheque was issued for an amount of 20 lakh rupees. After the cheque was issued, the borrower made a part payment of 409,315 rupees to the drawee of the cheque. However, the cheque was presented for 20 lakh rupees without endorsing the part payment. When the cheque was dishonored due to insufficient funds, the appellant filed a criminal complaint against the first respondent for the offence under Section 138. The trial court acquitted the first respondent on ground that the first respondent paid the appellant a sum of rupees 409,315 between the 8th of April 2012 and the 30th of December 2013, partly discharging his liability in respect of the debt of rupees 20 lakhs. On appeal, the Gujarat High Court upheld the judgment of the trial court acquitting the first respondent. Being aggrieved, the present appeal has been filed. The issues posed for consideration is whether the offence under Section 138 of the Act would deem to be committed if the cheque that is dishonored does not represent the enforceable debt at the time of encashment. The Supreme Court has held that the cheque that is dishonored must represent a legally enforceable debt on the date of maturity or presentation for the commission of an offence under Section 138. If the drawer of the cheque pays a part or whole of the sum between the period when the cheque is drawn and when it is encashed upon maturity, then the legally enforceable debt on the date of maturity would not be the sum represented on the cheque. When a part or whole of the sum represented on the cheque is paid by the drawer of the cheque, it must be endorsed on the cheque as prescribed in Section 56. The cheque endorsed with the payment made may be used to negotiate the balance, if any. If the cheque that is endorsed is dishonored when it is sought to be encashed upon maturity, then the offence under Section 138 will stand attracted. The first respondent made part payments after the debt was incurred, and before the cheque was encashed upon maturity. The sum of rupees 20 lakhs represented on the cheque was not the legally enforceable debt on the date of maturity. Thus, the first respondent cannot be deemed to have committed an offence under Section 138 when the cheque was dishonored for insufficient funds. The notice demanding the payment of the said amount of money has been interpreted by judgments of this court to mean the cheque amount. The conditions stipulated in the provisos to Section 138 need to be fulfilled in addition to the ingredients in the substantive part of Section 138. Since, in this case, the first respondent has not committed an offence under Section 138, the validity of the form of the notice need not be decided.
So, in the important judgment titled Sunita Palita and others versus Panchmani Stone Quarry, pronounced on 1st August 2022, the Supreme Court has held that it is not necessary to make an averment that a managing director or a joint managing directors were in charge of and responsible for the conduct of the business of a company to make them accused under Section 141 of the Negotiable Instrument Act 1881. The facts of the case would be that the respondent filed a petition of complaint against the appellants under Section 138/141 of the NI Act with allegation that the appellants, being the accused numbers 3, 4 and 5, were directors of the company. The appellants filed a criminal revisional application in Calcutta High Court under Section 482 of the CRPC, praying that the proceedings under Section 138 read with Section 141 of the NI Act pending in the court of the judicial magistrate be quashed, and pending such order, all proceedings in the said case be stayed. By the impugned judgment and order, the single bench rejected the application filed under Section 482 of the CRPC. Being aggrieved, the appellants have approached this court alleging that the appellants claim that they are independent, non-executive directors of the company who are in no way responsible for the day-to-day affairs of the company. The Supreme Court has held that Section 482 of CRPC protects the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under the CRPC or to prevent abuse of the process of any court or otherwise secure the ends of justice. While it is true that the inherent jurisdiction under Section 482 should be exercised sparingly, carefully, and with caution, and only when such exercise is justified by the tests specially laid down in the section, the court is duty bound to exercise its jurisdiction under Section 482 of CRPC when the exercise of such power is justified by the tests laid down in the said section. Jurisdiction under Section 482 of the CRPC must be exercised if the interest of the justice so requires. The High Court rightly held that when a complaint was filed against the director of the company, a specific averment that such person was in charge of and responsible for the conduct of business of the company was an essential requirement of Section 141 of the NI Act. The High Court also rightly held that merely being a director of the company is not sufficient to make the person liable under Section 141 of the NI Act, and the requirement of Section 141 of the NI Act was that the person sought to be made liable should be in charge of and responsible for the conduct of the business of the company. This has to be averred as a fact. The High Court also rightly held that the managing director or the joint managing director would admittedly be in charge of the company and responsible to the company for the conduct of its business by virtue of the office they hold as managing director or the joint managing director. These persons are in charge of the responsible for the conduct of the business of the company, and they get covered under Section 141 of the NIA. A signatory of a check is clearly liable under Section 138/141 of the NI Act. The High Court, however, failed to appreciate that none of these appellants were managing director or joint managing director of the company, nor were they signatories of the check which was dishonored. The High Court observed rightly that the laudable object of preventing bouncing of checks and sustaining the credibility of commercial transactions resulting in enactment of Section 138 and 141 of NI Act has to be borne in mind. A complaint should also not be read with a pedantically hyper-technical approach to deny relief under Section 482 of the CRPC to those impleaded as accused, who do not have any criminal liability in respect of the offence alleged in the complaint. The provisions of Section 138 and 141 of the NIA create a statutory presumption of dishonesty against those covered by Section 138 and 141 of the NI Act and expose them to criminal liability if payment is not made within the statutory period even after the issue of the notice. There can be no doubt that in deciding the criminal revisional application under Section 482 of the CRPC for quashing a proceeding under Section 138 and 141 of the NIA, the laudable object of preventing bouncing of checks and sustaining the credibility of commercial transactions resulting in enactment of sections has to be borne in mind. The provisions of Section 138 and 141 of NIA create a statutory presumption of dishonesty on the part of the signatory of the check, and when the check is issued on behalf of a company, also those persons in charge of or responsible for the company or business of the company. Every person connected with the company does not fall within the ambit of Section 141 of the NIA. A director of a company who was not in charge or responsible for the conduct of the business of a company at a relevant time will not be liable under those provisions. Liability depends on the role one plays in an affairs of the company and not on the designation or status alone, as held by this court in SMS Pharmaceuticals Limited versus Neeta Bhalla, reported in 2005, 8 SCC 89. So the High Court correctly observed that three categories of persons were covered by Section 141 of NI Act. The company who committed the offence was, as alleged, everyone who is in charge of or was responsible for the business of the company, and any other person who was a director or the manager or the secretary or officer of the company with whose convenience or due to whose neglect the company committed the offence. Even though the High Court depreciated the adoption of hyper-technical approach in construing the pleadings to quash criminal proceedings, the High Court adopted a hyper-technical approach in rejecting the application under Section 482 of CRPC on a cursory reading of the formalistic pleadings in the complaint, endorsing the contents of Section 141 of NIA without any particulars. What the High Court overlooked was the contentions of these appellants that they were non-executive independent directors of the company based on unimpeachable matters on record. The High Court observed that in the petition, it had specifically been averred that all the accused persons were responsible and liable for the whole business management of the company, and took the view that the averments in the complaint were sufficient to meet the requirements of the Section 141 of the Negotiable Instruments Act. In any event, there could be no justification for not dispensing with the personal appearance of the appellants when the company had entered appearance through an authorized officer. Therefore, the High Court erred in the law in not exercising its jurisdiction under Section 482 of CRPC in the facts and circumstances of this case to grant relief to the appellants. Thus, the judgment and order of the High Court is set aside. Criminal case pending under Section 138 and 141 of the NIA in the Court of Judicial Magistrate is quashed insofar as the appellants are concerned. It is made clear that the proceedings may continue against the other accused in the criminal case, including in particular an accused company, its managing directors, additional managing directors, and or the signatories of the check in question.
Hi friends, in this video we are going to deal with the important judgment titled Amarnath versus Jionchand and another, pronounced on 28th January 2022. The facts of the case would be that the plaintiff filed a suit for declaration by way of permanent injunction that he is the owner in possession of that property, and the mutation showing the sale in favor of the first defendant by the second defendant was null and void, and that the second defendant was not having any authority to sell the land owned by the plaintiff, and hence the defendant be restrained from interfering with the ownership and possession of the plaintiff. The plaintiff further alleged that he bona fide executed a special power of attorney in favor of second defendant for selling the property for the amount of rupees 55,000. As the negotiation fell through in view of the first defendant not being able to arrange the money, the second defendant to whom the power of attorney was executed surrendered the original to the plaintiff, and the plaintiff told the first defendant that the same stood cancelled. Thus, the second defendant could not execute the sale deed in the absence of the original power of attorney, and the sub-registrar was supposed to verify the aspect from the second defendant under sections 32, 33 and 34 of the Registration Act. The trial court dismissed the suit, and the same was upheld by the first appellate court. On second appeal, the High Court observed that in view of the cancellation of the original power of attorney, the same could not be relied upon by the registering authority for the purpose of execution of the sale deed. The High Court also held that as per Section 18 of the Registration Act, it was necessary for the registering authority to see the true copy of the special power of attorney. Being aggrieved, present appeal has been filed. The Supreme Court has held that Section 18A of the Registration Act contemplates the production of a true copy of a document which is sought to be got registered, and not the true copy of the power of attorney. When a person empowers another to execute a document and the power of attorney acting on the power executes the document, the power of attorney holder can present the document for registration under Section 32A of the Registration Act. Section 32C deals with agents of the persons covered by Section 32A, and agents of a representative or assignee falling under section 32b. It is in respect of such an agent that there must be due authorization by a power of attorney, which in turn is to be executed and authenticated in the manner provided for in section 33. However, the person who has actually signed the document or executed the document for the purpose of section 32A does not require a power of attorney to present the document. When section 32C of the Registration Act declares that a document, whether it is compulsorily or optionally registrable, is to be presented inter alia by the agent of such a person, representative or assignee, duly authorized by power of attorney, it must be executed and authenticated in the manner and hereafter mentioned immediately in the next following section. Section 33 by its very heading provides for power of attorney recognizable for the purpose of section 32. Section 32A cannot be read with section 33 of the Act. In other words, in a situation if a document is executed by a person, it will be open to such a person to present the document for registration through his agent. The agency can be limited to authorizing the agent for presenting the document, for it is such a power of attorney which is referred to in section 32C. It is in regard to a power of attorney holder who is authorized to present the document for registration to whom section 33 would apply. In the facts of this case, the second defendant was armed with the power of attorney dated 28/1/1987, and if it was not cancelled and he had executed the sale deed on 28/4/1987, he would be well within his rights to present the document for registration under section 32A of the Registration Act. The second defendant having presented the sale deed as executed, the presentation and registration cannot be questioned. Section 32C of the Registration Act read with section 33 and section 34 2C are interrelated, and they would have no application in regard to the document presented for registration by a power of attorney holder who is also the executant of the document. In other words, there is really no need for the protection of the original power of attorney when the document is presented for registration by the person standing in the shoes of the second defendant in this case, as he would be covered by the provisions of section 32A of the Registration Act, as he has executed the document, though on the strength of the power of attorney. To make it even further clear, the inquiry contemplated under the Registration Act cannot extend to question as to whether the person who executed the document in his capacity as the power of attorney holder of the principal was indeed having a valid power of attorney or not to execute the document or not. On an analysis of the provisions, this court has no hesitation in rejecting the argument of the plaintiff that the non-production of the original power of attorney by the second defendant was fatal to a valid registration being effected. The understanding of the courts regarding section 18A of the Registration Act is also erroneous. The trial court was right when it held that section 18A of Registration Act is concerned only with the document which is presented for registration. The trial court clearly erred, relying upon section 18A of the Registration Act to hold that certified copy, however being produced, of the power of attorney was in conformity with section 18A, and the High Court was equally in error to hold that section 18A of the Registration Act contemplated protection of a true copy of the power of attorney. The protection of the original power of attorney before the registering authority was unnecessary for effecting registration of the sale deed. The case set up by the plaintiff was that on the second defendant handing over the power of attorney to the plaintiff, the special power of attorney was deemed to have been cancelled in the eye of the law. There is no whisper in the plaint about the plaintiff having cancelled it in the manner in which he has deposed to in the evidence. proceeding on the basis that the second defendant had a duty to not sell the property below rupees 55,000 in terms of P1. The breach of duty to not sell below rupees 55,000 when the second defendant sold the property for rupees 30,000 cannot invalidate the sale or render it null and void. A perusal of the power of attorney will make it clear that any restriction on the price is conspicuous by its absence in the power of attorney. Therefore, the impugned judgment cannot be sustained. Friends, to conclude, in this video we have seen that the production of the original power of attorney is not necessary if the document is presented for registration by the power of attorney holder who executed the document on the strength of it, as per Amarnath versus Jian Chand and another case. In the next video I will see you with yet another case synopsis. Until then, I take leave of you. Bye.